Thank you very much, Mr Chair. I just want to firstly take up Mr Garrett's point about the amendments that the Labor Party has tabled here today. This is the committee stage. This is where amendments get tabled. It seems as if the Labor Party can't really do any right in Mr Garrett's eyes. Either we're not proposing alternatives and therefore we're just politicking, or we are proposing alternatives and therefore we're just politicking. I just urge Mr Garrett to look at these amendments. These issues have been around throughout this debate. There's probably nobody in this House who's been following this debate more closely than Mr Garrett. He knows what these amendments are about. He knows about the concerns about unjust sentencing. They were raised by the Ministry of Justice. They were raised by officials commenting on the Cabinet paper. He knows what the concerns are, and I would just urge you, Mr Garrett, to look at the amendments that Clayton Cosgrove has proposed and consider whether or not this actually fits with what the ACT Party have been telling people all around New Zealand about this bill. If we look at the manifestly unjust clause, the ACT Party put out a pamphlet that said the judge sentencing a strike-3 offender will have no option but to sentence the offender to the maximum sentence. The only exception is if the judge determines it would be manifestly unjust to do so. That's actually wrong. What the bill actually says is that the maximum sentence is actually mandatory. It has to be imposed. That's what this amendment is about. It's about actually making the concept of manifestly unjust mean something in this law, to actually address the point that was raised by the Ministry of Justice. So I really would urge the parties opposite to look at these amendments that the Labor Party is putting up. The Labor Party opposes this bill because we don't think it's going to work, and we do think it's inequitable, and we would rather be focusing at another end of the system. But we're now in the committee stages of this debate. And in the committee stages of this debate, we are prepared to put up amendments that will at least improve this bill, that will at least put it into a situation where it gives real meaning, in this case, to the clause about sentencing being manifestly unjust. But, Mr Chair, I also want to come to one of our other amendments. This is the one to Clause 586D, and this is actually to allow the court to reduce the sentence imposed by up to 25% to take into account the fact of a guilty plea. At the moment, the incentive to plead guilty, particularly as we get to the third strike offence, goes away. Why would somebody decide to plead guilty in this situation? And we all know that if there are fewer guilty pleas, that's going to mean greater costs, obviously, but it's also going to mean that victims will have to go through more trials. So we are trying to actually amend this bill so that we can allow guilty pleas to be taken into account. We have to think about this bill in terms of how it's actually going to work, not as a slogan, not as a set of slogans that allow people to go forth into the electorate and, like Mrs Gowdy, simply say this is going to deter repeat offending. Read the clause, read the amendment. The amendment is there to Clause 86D to insert a new subsection that will actually allow guilty pleas to be taken into account properly. Mr Chair, it's very important that in this debate we ensure that we try and make this the best law it can possibly be. The Labor Party believes this law is wrong. We do not support it in this House, but we do want to ensure that we actually give meaning to some of the terms that are here, to manifestly unjust. We also want to make sure that we put incentives in place so that people will plead guilty, so that we can reduce the number of cases where victims have to go through the horror again of what has happened to them. Mr Chair, we also have amendments within here to Clause 5, Section 86C, to insert after subsection 4A, where it says serve the sentence without parole, unless the court is satisfied, given the circumstances of the offence and the offender, that it would be manifestly unjust to make that order. So we're trying to cover off manifestly unjust as a meaningful statement in sentencing and in parole, and it's vitally important as we go through this bill, Mr Chair, that we do not allow ourselves to be sucked into the belief that this set of slogans will provide the panacea to these problems. We actually need real, proper amendments to this legislation to give it meaning. And, Mr Chair, we have not seen that at any point so far from the government or the ACT Party. All we've seen is a continuation of the cliches and the slogans rather than attempting to see how the bill would work. And I think Mr Garrett has said to us before that he wants this bill to work properly. He wants this bill to be meaningful. He needs to adopt these amendments.
Sandra Gowdy.
I move that the motion be